In view of the aforesaid discussion, we are of the considered opinion that the materials and evidence in the instant case would not be sufficient to come to a conclusion of guilt of the appellant with the offense in question. So and so, appellant is accordingly acquitted by giving the benefit of doubt. LC returned. Matrimonial appeal 21 of 2021. In view of the above, we are of the considered opinion that the conclusion arrived at by the learned family court is based on the materials on record and does not call for any interference. Appeal is dismissed. Yes, Mr. Das. 17. But some wrong record has come. Okay, okay. Okay, okay. Sri J. Das, Learned Legal Aid Council, has informed that though in the cause list, the criminal appeal within bracket jail 53 2024 bracket name has been shown. The records of criminal appeal 53 of 2024 has been sent to the court registry to look into the matter. And the matter accordingly stands adjourned to be listed along with the proper records. Ms. Lee Bhuya, Learned APP is present. Okay. Nine, yes. Yes. You're for whom? Appellant. Okay. On a request made on behalf of the appellant, matter is adjourned by 2 weeks. Yes. IA for? IA for? You have filed fresh or it was filed along with the appeal? Which year? Okay, fresh application. Okay, we'll have it next week, whenever you want. 29? Tuesday. We'll have it on 30th, 30. Oh, 30th October. 30th, Wednesday. 31st क्यों बंदा? दिवाली. हाँ, दिवाली. Yes. Okay, okay. 13 same order, huh? As 9. 2 weeks. I think your microphone is not working. Is it working? Not working. Just now. Yes, it's working. Yes, now it's working.
This appeal, matrimonial appeal, we have filed against my divorce petition, which was filed under section 13(1)(a), the Hindu Marriage Act, and which was dismissed by the court below by order dated 11 05/2022.
What is the aspect of the cost of 3,000? What is it?
This was regarding the delay condonation
Okay. Delay has been condoned.
that has been
Okay.
condoned.
Cost of 3,000.
3,000.
Okay, you have paid the cost.
Yes.
Okay. Your Siddhant,
Yes, sir.
Heart Sri Siddhant, Datta, Learned Counsel. Here for whom?
I am for the respondent, your lordship.
We are admitting the appeal.
Yes, yes. My name has not been shown in
Okay, we'll directly showing your name. Who's do Upamanyu? With you?
last.
D. Upamanyu was for the health department.
How is he connected?
Because one certificate was issued stating that
That's a different matter. How is he connected? He'll not be a party in
no,
this.
we have
Regarding one
regarding-
prescription, that genuinity of this,
so health department was called for to explain the certificate issued by the
Okay.
doctor.
Heart Sri Siddhant Datta, Learned Counsel for the appellant who has preferred the appeal under Section 19 of the Family Courts Act 1984 against the judgment and order it is so and so. By the aforesaid judgment, the suit for divorce filed by the appellant under Section 13(1) within bracket small 1A of the Hindu Marriage Act 1955 has been dismissed. Para 3. Datta, the Learned Counsel, has informed that the delay in preferring the appeal has been condoned, and he has also paid the cost which was imposed by the court while condoning such delay. Full stop. Seen the note by the Registrar General in this regard. Full stop. Para. Admit. Call for the records. Since Ms. K. Fukan, Learned Counsel, has already entered appearance for the sole respondent, issuance of formal notice is dispensed with. However, let a copy of the memo of appeal be served upon her within 2 working days. List after 6 weeks, along with for a report on the service of on the receipt of LCR.
Ablash.
I for what?
I for stay.
Stay. Stay of what?
I has been disposed. I think that is for condonation.
Condonation.
obliging.
The name of Miss K. Fukan be reflected in the cause list
Obliging.
as counsel for the respondent. Jail appeal. This appeal has been referred from jail against so and so. Admit. Call for the records. Conviction under what?
Lordship, we didn't receive the copy.
Miss A. Begum, Learned APP, accepts notice on behalf of the state respondent. Let steps be taken for service of notice upon the informant/victim in the manner prescribed by the registry. List after 6 weeks along with service report as well as receipt of records.
Copy may be started.
Hmm?
Copy not. Petition copy don't have that.
You don't have.
Paper.
Let the records come first. Then we'll
Notice
notice you have already issued.
that will go to our clerk because it's according to the process.
Saying without any copy, how to bring the notice.
Okay. Let the registry furnish the copies of the concerned documents to the Learned APP for doing the needful. Amicus live. 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 sorry. Admit officer, huh? Admit, call for a record. Three.
AM Datta, sir, AM.
Three AM Datta, learned empaneled amicus jury is appointed to assist this court as amicus. Let his name be reflected in the cause list.
Next, please, Lord. And let's say item 3 may continue at the 3 weeks, Lord.
Admission.
Last week.
Why are you seeking admission?
Last week, today I'm not feeling well.
No, it's an admission, a criminal appeal against conviction or what?
Last,
What, you're not feeling well, will it have any
maybe.
impact on admitting the appeal?
Last. Last,
We admit the appeal.
Last.
Statutory appeal, isn't it? Or is there something else?
yeah. 302.
We admit the appeal,
Last,
heard three, E. Divan. Learned counsel for the appellant who has preferred the appeal under Swenson, huh? Against Swenson. Admit, call for the records. Miss A. Begum, huh? For respond number 1. That steps be taken for service of notice upon the respond number 2.
302, Lord.
Please, through the, how will it go?
For register.
Steps, within, please, within 2 working days. List after 6 weeks along with, huh? Along with service report as well as read of records, receipt of records with us.
This is criminal appeal in conviction, but
Under?
Pokso, Lord.
under POCSO, but
Foxlo?
Yeah.
Okay, same, huh? Etu holo J prime আর Foxlo হবো তো? Etu. Same order. We admit to calling for the record.
yes,
Take steps. It'll go through you,
Lord.
in the prescribed manner. 6.
all right. Please, your lordship. Lordship, brief have been taken away from our conduct, so my name will be right. I have already cleared also.
We would have otherwise admitted, but since that will not serve the purpose, we adjourn for some time, okay? Sri D. Sharma,
Yes, ma'am.
learned counsel has informed that though the appeal was filed by him, the brief has been taken away. Full stop, it appears that no press counsel has been engaged till now. Full stop, para. Miss A. Begum, learned APP is present. Para, in the interest of justice, list after 2 weeks for admission. Next time, I will admit for MI.
May it please your lordship.
Yes.
It's a fresh matter, my lord, convicted for 364A of the IPC, my lord.
SD, huh? Admit, huh? I'll see her. Good luck, Katie, what's up? I do to say, one. At a state respondent. A Begum. Yet records, local receipt of records. Very nice. Private respondent, nice. Okay. Much obliged. IA for what?
I for suspension of sentence.
Okay, let the records come, we'll
Sure.
consider. We can issue notice in the IA.
Yes,
This is an heard restraint, huh? Who for the who appears for the applicant in this application filed under section so and so, by which he has prayed for suspension of the judgment dated so and release of the applicants on bail. Para, let notice be issued. Ms. A. Begum, Leonard APP, accepts notice on behalf of the sole, on this, accept notice on behalf of the state respondent. Let extra copies of the application be served upon her within 2 working days. The application would be considered on receipt of the records, which have been called for in connection with the connected, and which have been called for in the connected criminal appeal so and so.
Much obliged.
Items 6 and 7.
What particular job?
That sentence.
Yeah, that's why, my lord, I have been appointed as an amicus curiae, but unfortunately, I am yet to receive the paper book, my lord.
Paper book otherwise has been prepared?
Yes, my lord.
Okay. 2. Okay.
Have you received?
We have received,
Okay.
yes.
Tomorrow?
3. Jet Kamar, Learned Senior Counsel, has appeared in terms of the order of his engagement passed by this court on 22/7/2022. Full stop. It however appears that though the paper book has been prepared, copies of the same have not been furnished to the concerned counsel. Full stop. Let the registry furnish copies of the paper book to all the concerned counsel and the matter be listed for hearing thereafter.
Much obliged.
And the matter be listed for orders to fix a date of hearing.
That will be better.
That will be better,
Yeah.
as per your convenience.
For all convenience, my lord, because death sentence will take some time also, my lord.
Okay.
Much obliged.
Yeah, item 7, but I am appealing to for the appellate part. I
Seven
have
is connected.
connected, but I have
Three.
prepared an
Three,
appeal part.
H. Dr. Leonard
I have
Counsel is
Oh.
present for the appellant in the connected criminal appeal suits. You have got paper?
Yes, I have.
Kindly coordinate with the registry for the paper book.
Yeah, my lord, I'll send my thing here also. Much obliged.
Yes.
In this case, step was taken up with the respondent to speak. On number of occasions, it took time for producing.
Lordship, today I have ring with the IC Lordship. He had informed me that he have received the copy, but he is out of station, Lordship. So he is not confirmed that whether report is sent to us or not, but it is received by him, the notice.
My lord,
So he needs till Tuesday, Lordship.
Short time will be.
Lord,
The appeal is at the stage of a report on the aspect of service of notice upon the respond number 2, correct?
2 and 3.
2 and 3.
Three.
Who is 3?
My lord, 2 is the informant, 3 is the victim.
Or 2 and 3? Miss A. Begum Learned APP, Assam, has submitted that as per telephonic instructions, some steps have been taken by the concerned officer in charge, Haflong Police Station. First, however, the official communication in this regard is yet to be received by her. Full stop. She accordingly prays for and is granted a week's time. Full stop. List on Friday next.
Lord.
Bring Friday, I think it's a holiday.
Holiday.
List on, we'll have it on 4th of November.
Right.
4th of
Okay.
November. You're getting adequate time, madam, get the report.
Item 10.
May I please, your lordship? Lordship.
Mr. Das, you were not present on earlier occasion.
Lordship,
Why?
I beg to apologize, lordship. I was
Be
spotting-
there.
I was caught in,
Amicus Curie Legal Aid Council has added responsibility.
I deeply apologize, Lordship. I was caught in the.
We look for you, you inform Ms. Bhuya also, you are
Lordship,
not there.
Lordship, eh.
What is this?
Lordship, this is the appeal with regard to conviction of the appellant under section.
Appeal has been admitted.
Appeal has been admitted, Lordship, but there is a IA pending with regard to suspension of sentence
A conviction under what?
under 302 of the Indian Penal Code, Lordship.
Okay, but records have come. Paper book बनाई नहीं.
Okay, so to test now.
We'll direct preparation of the paper book.
Lordship.
What evidence is what? Direct evidence?
Lordship, is circumstantial. evidence,
Circumstantial
Lordship.
evidence.
Yes, sir.
What is your case for suspension?
Lordship, basically, there are two grounds, Lordship. One is that the deceased is the wife of the appellant, and they are with two minor kids. And they are from a very, they are tea garden workers. So now there is no one to look after those kids. That is one of the ground which is very necessary and urgent. And they're minor kids, Lordship.
What are the age?
Lordship, as what I have got that they are minor, that's what is from the record. I mean, we have not been able to communicate with that. But
You don't know the age.
not the exact ages are not known, but as per the evidence, they were.
They are living with whom now?
Lordship, I haven't, but as per the records at that point of time, they were with the father during the trial.
No,
But-
no. Now they are living with whom? The
That is not clear.
grandparents, uncles, auntie, whom?
Lordship, that is not
Try
clear,
to get some information.
Lordship. Because he is in jail, Lordship, and there's no one else in the family.
And on the, what other grounds?
Lordship,
Yes.
basically, the allegation of the informant, who is the brother of the deceased, was that he heard from the night chowkidar that actually both the deceased and the appellant, they were husband and wife, and they used to consume alcohol regularly. And what his version in the FIR was that on that fateful night, they had consumed alcohol, and there was a fight which came out, and thereafter this person assaulted her, and she died. And
Assaulted
by the husband, the appellant.
assaulted by sharp weapon.
No, that has not been said. Only say that there was an assault which that appellant had informed the chowkidar. The chowkidar informed the informant. But later on, during the trial, Lordship,
PM.
it says that the blunt object, sharp or blunt object, there is a head injury. So now the stand of the appellant in the whole of the trial was that that night, fateful night, she had consumed alcohol. And while coming to the tube well, she fell down and she got that injury. And moreover, Your Honor, that chowkidar, who was the prime person who informed the informant, he also deposed that he has never stated about any assault. Even the informant has admitted on record that there has been no information received with regard to any assault being informed to him by the chowkidar.
No, what is the evidence on the assault then?
There is no evidence, Lordship. Only the medical evidence is there where she has got a head injury.
No, medical evidence will not be on the aspect of assault. Medical evidence will be on the aspect of injury.
Yes, Your Lordship, but
Now,
none, no evidence as such.
how is it possible? Madam?
Although I have not gone through the records of the case, my lord, the accused person lived with the deceased during a fateful day. So he should offer an explanation. Probably the son or some of
No,
the
first,
witnesses have
Now,
deposed.
106 will come in. First,
Yes.
you discharge your initial
Yes,
burden.
my lord, that is there. Lordship,
There
that
has
is
to be at
there.
least some indication that there was an assault.
Yes,
If that is not there at all,
My
then
lord.
how do you presume that there is no presumption?
but one of the witnesses have deposed. From my objection, I'm reading, my lord, that he was there in the residence. The children, one of the son or the daughter, someone
Yeah.
has informed one of the witnesses that accused person was very much present in the fateful day.
No, his
Lordship,
presence,
yes.
we are not even disputing
My
his
lord,
presence.
but regarding the assault, I have to gone through the records, your lordship, I have not gone through because LCR is available now only. Let the
Only the
paper book be
chowkidar's
prepared, my
version of
lord.
telling the informant. That is the only where he was informed by the appellant himself that there was a fight which erupted that night.
See, even if there is no allegation of any assault,
But-
if the manner of death was slightly different,
My lord,
maybe by hanging or there is ligature mark on the neck, there is only blunt weapon, blunt object.
my lord.
Without any allegation of assault, can you presume in criminal law?
Lordship, then if your lordship takes up the IA, then I may go through the records.
LCR ऐसे नहीं कहने. Where, someone said. These have been discussed in the judgment.
Lordship.
What is the finding? How is the finding arrived at?
Lordship, basically that because most of the witnesses were declared hostile. All the, I say, there were 7 witnesses, half of them were declared hostile. So based on that, there was an assumption made that since that on, and one very a neglect was there with regard to that defense stand that was taken by the court in the other way, saying that the accused never explained. As to,
106.
yes, that burden was not being able to be proved.
Lordship, then, this one, extrajudicial confession before PW1 from page 50, para 53 of the judgment. Lordship,
Who is
there is
PW1?
PW,
brother of the-
brother of the deceased. This is also evidence of PW1 that the accused confessed before him that the accused assaulted his elder sister on the previous night. As a result, his elder sister died, and his and that piece of evidence
Was
of
it
PW
also
remained
stated
intact.
before the police by PW1?
So I
That is where the his declaration of hostile came in, Your Lordship, because he stated specifically that it is not a fact that I stated before police. I, on reaching the house of my sister, noticed several injuries on the person of my sister, and my sister and brother-in-law confessed before me that he assaulted my sister as a result of she died.
See, extrajudicial confession, it's a
Weak.
weak piece of evidence. And if such statement was not made before the police in 161, then it becomes
I
absolutely
have
weak.
not gone through, my lord.
And as per the Lordship PW1's evidence dated 24 January 2019, the children are
The
aged.
conviction of which date?
Lordship,
You're in jail from which date?
Lordship, I am in jail from
Appeal of 2023.
2020, you were in custody, in jail.
28/6, sorry, Lordship, 28/6/2022, Lordship. And Lordship, as per the PW1's deposition, the children at that point of time were 9 years and 5 years. That is on 24th January 2019.
Let the paper book be
We
prepared.
ask for preparation of the paper book expeditiously.
Yeah.
We'll try to have this on priority basis.
Right.
Okay. Heard 3 MK Das Learned Legal Aid Council
Lordship,
for the applicant appellant. Whereas Ms. B. Bhuya Learned additional PP is present for the state respondent. Full stop. Though the Learned Legal Aid Council has pressed for suspension of the impugned judgment and release of the petitioner, release of the applicant on bail, comma. We have noticed that pursuant to the order dated 38/2023, while the appeal was admitted and records were called for, comma, the said records have been received, full stop. Para. After considering the matter, comma, we are of the opinion that instead of considering the present application, comma, the appeal itself can be heard. Full stop. Accordingly, we direct the registry to prepare the paper book expeditiously and list this case for hearing immediately thereafter.
I'm deeply obliged, Lordship. And I again apologize for my.
As per opinion of the doctor, there are not only blunt object, sharp object is also there. As per opinion, injuries. Sharp object is also
Yet to receive the paper.
Prepared,
Yet to receive.
prepared or not?
Lab first, lab must take out.
আহিছে পেপাৰ বুক বনোৱা হৈছে নেকি? ৰেকৰ্ড আহিছে? বনোৱা নাই ন? You're an amicus?
Am I correct?
heard Sri M. Dr. Learned Amicus Curie for the appellant, as well as Miss A. Begum Learned APP Assam. Full stop. Pursuant to the order dated, pursuant to the order dated 19/6/2024, the records of the connected POXO case number so and so have been received. Registry is directed to prepare the paper book expeditiously.
Okay.
And list the matter for orders to fix the date of hearing. Mr. Bora, waiting for which matter?
50.
You are not there. Oh, you are for the respondent.
Yes.
Other side?
Mr. R D.
Today, it may not be possible. Hearing matters. Because of some other personal issue, we intend to rise slightly early. But in that case, we'll have a date. Conviction under what?
No, my lord. Here the appeal against an acquittal.
Acquittal.
Four of them are, my lord, there were five, my lord. Four of them were convicted. One was acquitted. The person who actually hit the deceased, my lord.
We had dealt with this matter on an earlier occasion. You said some other cases they were acquitted. That matter.
Yes.
That matter.
Yes. But ultimately, there is a conviction by four accused ballot, and all are acquitted by the High Court with an observation that the all eyewitnesses cannot be believed by. Doubtful.
Okay. Now, why is this conviction?
So he was acquitted. Four was convicted by the trial court.
Okay, those petitions have been, appeals have been allowed.
Appeal has been allowed with an observation regarding the eyewitnesses that these eyewitnesses are not truthful
Okay.
by the division.
Okay, we'll have it on when.
It took it on my-
Next.
But you kindly, the criminal appeal, 234 may be also called for, 234/2015,
Disposed of matter.
dispose of. Dispose of matter on
Heard three RD Leonard Counsel for
490.
the appellant. Also heard Miss Bhuya will be appearing.
Lordship.
Miss B Bhuya Leonard APP Assam. Puts up 3 AM Bora. Then senior counsel is present for the respond number 2. Respond number 2. Who informs that that the records of criminal appeal number
234/15
234 of 2015
disposed of on 4/9/2018.
disposed of on 4/9/2018 would be relevant for adjudication of the present appeal. Post of para. Let the aforesaid, let the record of the aforesaid appeal be tagged and the matter be listed for hearing. When? Tell us the date of your convenience, Mr. Day, Mr. Bora.
November.
7th of November, is it okay? Thursday? 7th of, okay. 7th of November.
May I plead Lordship? Lordship, appeal has been already admitted and LCR received Lordship. Lordship may direct to prepare the paper book Lordship.
LCR has come.
Lordship.
Heard Ms. D. Borpujari, Learned Legal Aid Counsel
Lordship.
for the appellant, as well as Ms. A. Begum, Learned APP Assam. There are no other respondents.
No, Lordship. 302.
Para, pursuant to the order dated 21/8/2024, the records of the LCR have been received. LCR for S. LCR have been received. Para, registry is directed to prepare the paper book expeditiously and list the matter for orders to fix the date of hearing.
Public.
May it pleases your lordship, I'm representing as legal aid counsel, although the name has not been reflected as legal aid counsel.
Yes, what is this? First time it has come.
Lordship,
Yes, your lordship.
I for,
There is a IA for delay of condemnation.
condemnation of the.
89 days delays
okay.
has been
Third
offered.
Miss
your
P.
lordship.
Das learned legal aid counsel for the applicant who has filed this application for condemnation of delay of 89 days in preferring the connected appeal against the judgment and order dated so and so, passed by so and so. Para. Issue notice. Miss A. Begum, learned APP Assam, accept notice on behalf of respondent number 1. Let steps be taken for service of notice upon the respondent number 2 by the manner prescribed for such steps within 2 working days. List after 6 weeks for service report.
Your lordship, kindly register me direct to show legal aid counsel.
Your name is there, Miss P. Das learned counsel is to be referred as legal aid counsel in the cause list.
Deeply obliged.
How long will you take?
It'll take some time, because there are a number of
If you
witnesses.
complete in the first half, we'll take up.
I think I'll be able to complete it in first.
But there is for 15 witnesses.
But the short, there's not very long.
Offense, conviction under
302 Malad, circumstantial evidences Malad. And I've got 2 people saw them fighting Malad. I mean, they were in fighting, but thereafter they parted. Now on the basis of that, the conviction has been Malad.
and what is the, that is the result of what?
Malad, some sharp injuries, it's say.
Sharp injury.
Sharp injuries, made, but we said including, it could be anything, Malad, object, heavy object, including sword, Malad. What is the
Sword.
medical say?
We have time, I think we can complete it. Yes. You take 1 hour and madam will take half an hour.
Malad. FIR is at page 4, Malad. Humbles.
You're amicus.
Amicus, Malad. Yes, sir. Page 4 is the FIR.
Yes.
Humble submission is that around 8 p.m. yesterday, my younger brother, Sanka Chik, son of late Lamu Chik, went out of the house and did not return home in the night. On 18/18, today in the morning, I saw that his dead body near Kali Mandir temple at line number 10 of the Digali Torong tea estate. There are so injuries on his face and head caused with sharp weapon. I suspect that some unknown miscreants had left my younger brother near Kali Mandir after killing him. I therefore pray to take necessary action against the upon investigating the matter and apply. Then my lord,
Ashok is what? PW?
Ashok Chief my lord is my lord PW 2 my lord. My lord, PW1 my lord is the doctor my lord.
Just a minute. He did not name anybody in the
Did
inquiry.
not name anybody, did not name.
What is the name of the appellant?
Appellant's name, my lord, is
Kumru.
Kumru
Bhumiz.
Bhumij.
Lord, I'm sorry to indulge. In the last order, Lordship, item number 14, Lordship has noticed to the informant Lordship, but the matter is not admitted yet, Lordship. So filing number is not there.
In
Item
the
number
IA.
14. Yeah, Lordship. That is,
IA.
I was one for condonation of delay, Lordship. And the matter is new matter. So it is for filing.
Condonation of delay, where is you notice?
No, informant 6 weeks.
She is a party in the in the condonation application. We are not
I
passing
thought
orders on
that,
the. We are not touching the appeal unless we condone the delay. How do you touch the appeal?
Lord,
Notice has been issued in the IA.
Lord,
Just before going to that, my lord, I'd just like to point out one aspect. But I'm not very sure whether this the date is correct because the 313 statement, my lord.
Yes, please.
So before going to the evidence,
Yes.
I'd just like to point out one aspect of your lordship, my lord, because this may have some relevance.
Yes.
My lord, in the 313 statement, I'm not sure whether the date is correct in the my lord, paper book.
Hmm.
Lordship will see at page 39. 29. So page 29, my lord.
29.
29, my lord.
Yes.
Examination of accused under section 364, 313 of the criminal procedure
Hmm.
code. Now, my lord, this is of course, whether the date is correct on different records, it can be certain. 6th February 2019. It is perhaps 2020. My lord, and the age is about 20 years. Whether, my lord, there's one aspect maybe whether this person was a juvenile at that point of time. That of course, my lord, is the Kumru Bhumiz was 20 years about in 2000. If it is, lord, 2020 was 20 years. At the time of the incident, my lord, he might have been a minor, my lord. Of course, that is not borne out of any other document or, my lord, evidence. But it may have some relevance in the final, my lord.
But this was in February 2019.
No, it should be 20 because, my lord, the evidences were completed in 19, my lord. 2027 November 2019, my lord, the evidences were completed, my lord. So it couldn't have been, my lord, perhaps some in 19, my lord. It could have been in 2020 only. That's why I'm saying, my lord, the original records may reveal it. It may be some
We'll
type.
just have a look, don't worry.
Agree.
please. About the incident.
About About 18, so there is nothing on record to really code.
Document is for-
Document.
Date বিলাক কিয় নিদিয়ে সেইবিলাকে? Fine কৰোঁতে। আমাৰ ইয়াতে original
এনে
rate
প্ৰায়
পাইছোঁ।
মোটামুটি।
Is there or-
নাই, sign কৰি date দিব লাগিছিলে।
that was not possible.
আৰু ইয়াতে আছে তো 6th day of February 2019 আছে। Examination of students আৰম্ভ কৰিছে এইটো, তো question বিলাক ঠিকে আছে। Question বিলাকৰ পিছত আকৌ সেইটো এখন আহিছে, examination of students। এইটো আৰু আছে 17th February 2020। 17 টো correct হ'ব।
It was, to say date of incident আমার 2018 হয়।
অঁ,
2018 already হয়, এটা যদি 19 হয় বা 20 হয়। অর্থাৎ
এই ইস্যুটো কেতিয়াও লোৱাই নাই না।
হয়
না, 18
না, criminal নহয় তেতিয়া।
হ'ব পাৰে।
Suppose incident date of 2018
18 ত।
আৰু সেই 20 বছৰ বুলি কৈছে।
20 বছৰ 2020 হৈছে।
তেতিয়াহ'লে যদি
18 হ'ব পাৰে, নহ'বও পাৰে।
নহ'ব পাৰে।
কিন্তু সেইটো ইস্যু লোৱা নাই না, হ'ব দিয়ক।
That cause was not raised in. But since it came to my notice, I thought to point it out.
No, even if it is not raised, it is the duty of the court
Yes,
actually.
yes, it
That's
can be
a-
raised at any point of time.
Any point of
Yeah,
time,
any
but
point.
that we don't think will make, it's a very marginal kind of.
Marginal maybe, margin. It says about 18, so it may be about 20.
About
So it
yes.
can be in
Yes,
touch and
yes.
go.
Okay, please proceed.
Lord, PW1, my lord, this is the doctor, my lord, Dr. Rajdeep Guha. On, he says, my lord, page 8, my lord, on 18/2/18, when I was working as the SM of Civil Hospital, Tinsukia, performed postmortem examination for the dead body of Shankar Chik, 23 years, male and police requisition in connection with Hagdan PS case number Swenso. The body was identified by Swenso and Promestic brother. On examination, found as follows. Then external appearances. The following injuries are seen: 5x2 lacerated wound injury over left eyebrow, 2x5 lacerated injury over right eye, below right eye, 1 cm into 1 cm over lacerated injury over bridge of the nose, 7 into 3 cm lacerated injury over chin, multiple abrasion and laceration of different shapes and sizes present over face, 5x2 cm lacerated injury over left forehead, 3x2 lacerated injury over occipital region, fracture of frontal bone, frontal left temporal and occipital bone, fracture of mandible, right maxillaris and nasal bone, subdural and subanechoid hemorrhage. Then pleural larynx trachea, both lungs, mouth, pharynx, esophagus were all congested. All other organs are normal. Opinion: in my death is due to shock and hemorrhage as a result of head and bodily injury received as described. All injuries are antemortem and homicidal in nature and consistent with sharp, heavy object trauma. Approximate time since death is within 12 hours. Exact exhibit 1 is a postmortem report. 1 is my signature. In my opinion, the injuries may have been caused by sharp
Yes.
and heavy object.
Yes.
And then PW2 is the informant.
Informant.
Informant, Ashok Chik. I'm the informant in the case. I know the accused present in the dock. The incident took place on a day of 18th of this year, about 3-4 months back. On a day morning, I came to know from my wife that my brother Shankar Chik was lying dead near a temple. The temple was situated at a distance of 100 feet from our house. Then I went to the place of occurrence and saw my brother lying dead. I became shocked, witnessing that my brother had injury in his face and head. Police was informed. Police came to the place of occurrence and sent my body for brothers for post-mortem examination. I lost the Azhar Exhibit 2 before the police. Exhibit 2 is my signature. Police recorded my statement.
No,
Then
this is not relevant,
This is not relevant, matter.
not connected at all.
Not connected.
Show
Then-
the connected.
Millard connected, Millard, Lordship will find Millard 2, Millard is also Millard again, Millard hearsay. Sorry, 3, my lord. 3 also did not see anything, my lord. 4 also did not see anything.
PW did not even mention the name of the appellant.
Name of the appellant, my lord.
And PW3, who is PW3?
PW3, my lord, is one, my lord, Shakti Kisan, my lord. He is, my lord, resident, my lord, nearby resident, my lord. Walking distance from my house. He saw a gathering, my lord. Then, my lord, PW4 is one Ajoy Kisan. He is the son-in-law of the informant. He also said that he knew from his father-in-law, nothing more. Then PW5 my lord, he says, my lord, at the time of accident,
Just go, PW three is.
Three minutes.
Shakti four is,
Shakti Kishan,
my informant is father and put my signature, but
Nothing.
it doesn't say anything.
nothing, my lord. PW five, my lord, similarly, he saw the dead body. Nothing, my
No
lord.
name, Caesar witness.
Hmm.
PW four, he's just a Caesar witness. Then PW five,
PW five, my lord, is one Rajesh Daud, Dasud,
just
Dusad. He is, my lord, he said that he was at home. He saw one dead body.
PW five is.
Police recorded his statement in the
Dusad.
incident. Cross, he says, I know nothing about the incident.
Okay.
PW six, my lord, was one Bikash Bhuya.
Yes.
He also says, my lord, that he saw the dead body. Persons were, my lord, gathered, my lord, gathering, and the person was lying dead on the ground. So nothing, my lord, nothing has been, my lord, stated,
Nothing.
nothing. my lord. PW seven, again, he also saw a gathering.
Then which is the evidence?
PW eight.
PW eight onwards, my lord, there are, my lord, PW eight and 10 mainly. Now, PW eight, my lord, deposition of PW eight is on Bablu Urang.
His deposition will be relevant.
His deposition will be relevant, my lord, because his deposition and that of PW ten, my lord, are the ones which have been, my lord, relied
Okay.
upon.
Okay.
And, my lord, PW, my lord, 13 has been declared hostile, but it may be relevant, my lord.
Bablu Orang, yes, let us see.
PW
Bablu
eight,
Orang.
Bablu Urang, yes. I know the informant and the accused both.
Yes.
I know the informant and the accused both. Around 3-4 months ago, the incident took place. While I was returning from work, at around 8-9 p.m., I saw deceased Shankar and accused Kamroz were fighting near the people tree of line number 10 of Digol Torong Tea Estate. Then one person named Chilu, who was in the residing line number 10 of Digol Torong, called upon me and asked me to stop the fight, as he could not alone stop the fight. Then I pulled Kamruz and Chilu pulled the deceased Shankar. Then both of them went away in different direction. Then I and Chilu went home. I do not know what had happened. Next morning, I saw people were gathered near the people line number 10 of Digol Torong Tea Estate. Then I went there and I saw Shankar was lying on the ground. Police came to the place of occurrence and recorded my statement and took me to the court and recorded my statement. 4 is the signature. 4-1 is my statement. 4 is 1 is the signature. It is not a fact that I did not state before police in the court that I saw deceased and accused were fighting near the people tree of line number 10 of 10 of Digol Torong Tea Estate. Near the place of occurrence, there was residence of many people. It is not a fact that I deposed today in the court falsely that the accused was involved in fighting with the deceased near the people tree line of line number 10 of Digol Torong Tea Estate. So he also did not see the exact incident. They were just seeing them fighting. And my lord, thereafter, they went away to different directions. Then, my lord, PW9 again, my lord, she did not see the, my lord, she told that her son told her about the incident, about a 10-year-old boy. PW9 is one, my lord, Parameshwar Sheikh. He also did not see the dead body here as he has fear psychosis. Police recorded his statement. And in process, I do not remember when I put my thumb impression on the exhibit 3. Police asked me about the incident, but I could not say who
It is not relevant.
Not relevant.
PW9 is not relevant.
No, not relevant. PW10, my lord. I know both the informant. This is one Milord Pilu Mura Milord Chilu Milord. This is the person Milord who is supposed to Milord the spelling. Yes, Milord. He is the person Milord who Bablu Orang says Milord, who had seen them fighting and asked him to
Chilu.
Chilu. So this 10 is Chilu Milord. I know both the informant and the accused of this case. The incident took place around 3-4 months back. The day was Saturday. The incident took place at night. Prior to the day of incident, myself and the accused were at Kherpatti near People 3. I saw the deceased and accused were fighting. I intervened their fight and stopped the fight. Thereafter, I went away to my house. He, of course, does not mention about Bablu Milord. I went to my house. Thereafter, accused told me at my house that he had killed Shankar. Then I told him to go to his house. Police recorded my statement. Then I also brought to the court. I was also brought to the court and my statement was recorded in the court. It is not a fact that the incident did not take place around 3-4 months back. It is not a fact that the deceased and accused were not fighting. I do not know the contents of the Ezhar as well as the statement I gave before the court. But I do not know Assamese and English. His statement, my lord, when my lord accused went to his house, my lord, and confessed, my lord, that is also the no time has been mentioned, my lord. It simply says, my lord, the fight stopped, then they went away, then the accused came to his place, no time mentioned, and confessed before him that he had killed Shankar.
Okay.
Then the next page, my lord, page 20, he further in his cross says, it is not a fact that the accused did not tell me at my house that he had killed Shankar. It is not a fact that I have deposed falsely today in order to implicate the accused. Then PW11, my lord, again, my lord, nothing, my lord. He also did not say anything. PW12, my lord, one Sarban Orang. He also, my lord, says nothing, my lord. He says that people are gathered in the place of occurrence. But PW13, my lord, she has been declared to be hostile. But her evidence may have some relevance, my lord, because 164 statement was also there in the paper book, my lord. She's one Hanumoti Dasud, my lord, Dusad. She is a PW13. I also do not know the informant. I know the accused person. About 1 year ago, at around 8 a.m., I was cooking meal in my house alone, and after taking my dinner, I go for sleep. On the next morning at around 6 a.m., I saw some people were gathering at a distance of 2 kilometers from my house. Then I went to the place of occurrence and I saw the dead body lying on the side of the road. I could not identify the dead body. Police was there and took my thumb impression in the paper. At this stage, the prosecution is free to declare this witness as hostile. The prayer was accordingly allowed. It is not a fact that I told police. I told before police that on 17 to 18, at night, the deceased Shankar Chik came to my house. Before coming to the deceased Shankar Chik, my husband, along with line Chokidar Rajiv Bekti, was sitting in my house. During that time, at around 7 p.m., after elapsing of 10 minutes of coming of deceased Shankar Chik, accused Kumru Bhumij and one Sirla came to my house. Sirla maybe, my lord, this is Sirla, perhaps it's Sirlu, my lord, because came to my house. During the time, deceased Shankar Chik asked the accused Kumru Bhumij his muffler, but Kumru Bhumij refused to give his muffler to Shankar Chik, and an argument and altercation had occurred. After about half an hour of occurrence of altercation, accused Kumru Bhumij, deceased Shankar Chik and Sirla went away from the house. So the three of them went together. And in the morning, at about 18/8/2018, at about 6 p.m., deceased Shankar Chik was lying dead near Kali Mandir of my house. I saw injury marks on his face, forehead, and head on the dead body of deceased Shankar Chik. Later, I came to know that Kurmu whom is over same line had murdered Sankar Chik. Cross-examination. My name is Srimati Bhanumati Dusad. I'm an illiterate. I do not know to read and write Assamese language. The distance between the house and the place of occurrence is about 2 kilometers. The place of occurrence is not visible to my house. The resident of Ashok Chik and the informant is situated about 2 kilometers distance from my house. Then, my lord, the PW 14, my lord, is the IO, my lord. On 18/2/2018, I was posted at Bhagjan PS as OC. On that day, I received the Ejahar. Exhibit 2 is the said Ejahar. Exhibit 2 is my signature. I took up investigation of the case. On the same day, I examined the informant Ashok Chik as a PS and recorded his statement. Exhibit 5 is the FIR form. Exhibit 5(1) is my signature. Exhibit 5(2) is the signature of the informant Ashok Chik. Thereafter, rushed to the PO, which is situated at Digoli Torong T line number 10 near Kali Mandir. I saw one dead body. The dead body of Sankar Chik, who was the brother of the informant. I drew up a sketch map at the PO. Exhibit 6 is the said sketch map. Exhibit 6(1) is my signature. I carried out inquest on the dead body. Exhibit 7 is the said inquest. Exhibit 7(1) is my signature. I forwarded the dead body for postmortem examination to the Tinsukia hospital. I seized one muffler in presence of the witness and I prepared a scissor list. Exhibit 3 is the scissor list. Exhibit 3(3) is my signature on the said scissor list. Of course, he has nothing is mentioned, my lord, as to when, my lord, he sent the dead body for the postmortem examination. It's not, my lord, stated, my lord. PW 15, my lord, is my lord, one Nobonit Kashyap, my lord. He was posted as
This
the
IO was not cross-examined.
IO, my lord, cross-examination. I don't find, my lord, here in my
Everybody would.
paper book.
It doesn't look that, looks like that it is complete.
Yes, my lord. Not different paper, different.
IO, not
It says PTO, then, my lord.
Listen, 7. There. Negative ইমান perform কৰিলে paper work কেনেকে হ'ব 5 copy আছে 2 page দিয়া নাই There are 2 pages 3 pages examination and cross examination. Obviously it doesn't look that it's complete. How can it be complete? There may not be cross examination, but at least there will be recording that cross has been declined. আমি এটা কাম করব এখানে ফটোকপি এটা করে লও পারিব আমরা পারিব আমার হেৰি ফটো মাৰি পেলাই ফটোকপি কৰি দিব লাগিব না এইখিনি ঘুমাব নোৱাৰিব এইখিনি 18 পেজ 16 17 16 আৰু 15 16 17 কিন এইখিনি ফটো মাৰি হোৱাটছএপৰে ওলাই দিব পাৰিব তেতিয়া এটলিষ্ট আমি ঘুমাই থৈ দিব পাৰিম লাগিব তোমাৰ কোনবা বিনয়টো নাই কৰা বুলি কি পাৰিব তুমি পাৰিবা কৰিব কৰাটো বহুত দিগদাৰ নাই ফটো মাৰি ওলাই দিব We'll do one thing. We'll make try to make some photocopy possible now, na recorder pa. Photo mari ulai di. Ha? Khuli bana lage. Photo mari ulai di easy hoye jabe. Khali photo kon bhalte mari le.
Photo mari WhatsApp পাঠাই দিলে
WhatsApp di print kore dibo pari. Ami etai kori. মই ডেমলালক মাতি দিছো এইটো হেৰি তন্দ্ৰ ডেমলালক মাতি দিছো তুমিও পাৰিবানে হোৱাটছএপৰ পৰা প্ৰিণ্ট লাও কৰা নে ট্ৰাই কি কৰা কথা আছে Yes,
Let the record.
we'll come back to the Ayu later.
My lord, then let PW 15, my lord, is the judicial magistrate first class, my lord, who recorded the statement of Pilu Milord Mura into. On 23/2/18, I was posted at Tinsukia as Chief Judicial Magistrate First Class. On that day, as per the order of the learned Chief Judicial Magistrate Tinsukia, I had recorded the statement of Pilu Mura, alias Chintu, aged about 26 years, and Sri Babulu Orang, aged about 19 years. Witness Pilumura Chintu had put his thumb impression, and my bench assistant Swenso had identified his thumb impression. Exhibit 9 is the Swenso, the 164 statement. Pilumura Chintu is my, exhibit 9(1) is my signature. Exhibit 9(2) is a signature of judge.
Translation করার করিছে এটি পিটিও লিখেছিল তারপর আপনি যে বাইরে ইন্ডেক্স করার চাই 25 বা 28 লগে লিখেছিল পেজ
পিছত হেৰি হ'ল
কিবা হেৰিখন পেজ নাপালে
পিছত আকৌ কাটিও দিছে কিন্তু কাটি দিছে
অটোমেটিক্যালি হেৰি কৰোতে কম্পাইল কৰোতে সেই দুখন পেজ নিদিলে
কিন্তু যেতিয়া প্ৰচেছৰ পৰা 28টো কাটিব পাৰিছে কিন্তু দুটা পেজ বেছি সোমাব পাৰিব
You are reading PW 15?
PW 15, man. Well, he says that he recorded this statement, man, and his bench clerk identified the person. Man, that much has been clear. Nothing more than that.
Statement of what? Whom?
Statement of Pilumura. Man. Pilumura, Chintu, and Bablu Orang.
This statement is under 164.
164, man.
How is it relevant?
Only to the extent that he recorded the statement, nothing more that much. And the 164 method.
I recorded 164. He has proved the 164 statement.
Yes,
that is all.
That is all.
He's the magistrate.
He has magistrate. In fact, my lord, next two pages I was saying. Yes. Same thing has been repeated, my lord. Page 27 and 20, the same thing.
164 statement of Pilu.
164 statement of Pilu is there, my lord.
Then?
And one Bablu Orang, my lord, this, my lord, I find, my lord, PW8 is there. Then,
how many witnesses? 15 is the last witness?
15 is the last witness.
Thereafter, okay. Oh, okay. Pilu Moran, Pilu Moran, signature.
Bablu was PW8 and before it. So we have
Pilu and Bablu.
Bablu is the PW8 who have seen the fighting lot. And
Bablu's, my lord, 164 statement is page 72.
Pilu is also known as Chitu.
Chilu, my lord.
Chitu.
But here it has been recorded as Chintu, which may not be correct, my lord. It's Chilu. It has been recorded as Chitu. In the, my lord, the magistrate statement, my lord, is recorded as in one place it is said Chintu, one place it is says Chitu. Pilu Moria alias Chintu. Again, he writes Pilu Moria alias Chitu.
PW 8 and 10, their 164 statement was recorded.
Record.
Okay, this is the only evidence. Thereafter?
My lord, PW 10, my lord, sorry, PW, my lord,
8.
9, my lord, that lady, my lord, who was declared hostile. Her 164 statement is recorded, my lord. She has been, though she denied having said all these things, my lord, that is, my lord, PW 13, my lord, sorry. PW 13, her 164 statement is also there, my lord.
Who has been declared hostile?
This PW 13, my lord.
Anumoti.
Anumoti, Tushar, my lord. Because Bhanumati Dusad said, my lord, that all of the three of them left together from our house where they had some tussle with regard to a muffler. Where my lord, the deceased and the accused had some tussle with a muffler, and the Chilu, my lord, went along with them. My lord, page 88 is our statement, my lord, under 164. Bhanumati,
Page
88.
88.
88. Statement of so. My name, address, age, and same as mentioned above. I'm a homemaker. On 17 to 18, deceased Shankarchik came to my house in the night. Prior to the arrival of the deceased Shankarchik at my house, Tokidar of our line, Sri Rajiv Bhakti, was sitting in my house. That the time was about 7 p.m. After 10 minutes of deceased Shankarchik's arrival in my house, resident of the same line, namely Kumru Bhumish, accompanied by Shirlo, came to my house. Deceased Shankarchik asked for the muffler, which Kurmu Bhumish had wrapped around his neck, but Kurmu Bhumish did not give the muffler to deceased Shankarchik, and therefore they quarreled with each other in my house. After half an hour of the quarrel, deceased Shankarchik, Kurmu Bhumish, and Shirlo together went out of my house. At around 6 p.m. on 10 to 18, I saw Shankarchik lying dead in front of Kali Mandir near our house. I saw injury marks on the face, forehead, and head of Shankarchik. Later, I came to know that Karmu Bhumish, resident of a line, had killed Shankarchik. My lord, what transpires, my lord, is that PW 8.
Just a minute, please.
Well.
Yes, sir. Oh, আৰু কপি তেওঁলোকক কৰি দিবা হা কৰি ইয়াৰ পৰা কৰিছো ফটো কপি কৰিছো তাৰ পৰা উলিয়াই হা
Well,
we'll come back, we'll come to the position of PW 14.
Well.
We're giving the copies.
Well.
What the copy?
No, well. Yes, ma'am. I examined the witness Shakti Kishan Rajesh Tusad, Vikas Bhuya, alias Kata, Bijoy Bhuya, Parameshwar Sikh, Shravan Ghumar, Ajay Kishan and the PO. On 22 to 18, the statements of Pilu Mura, Shirlo and Sri Bablu Orang were recorded under 161 CRPC. Later, they were forwarded to the learned court for recording the statements under section 164. That the statements of two witnesses, namely Rajiv Bhakti and Bhanumati Dasud, were recorded. Thereafter, the accused Kamruj Bhumij was apprehended at his own house and he was brought to the police station, was examined and his statement was recorded. Later, he was forwarded to the court. Thereafter, I collected the PM report and others. I seized one muffler, which I've seen in the court premises today, which is marked as Exhibit 1. Later on completion of the investigation, I submitted charge sheet against the accused Kamruj Bhumij under section 302 IPC. Exhibit 8 is the charge sheet. Exhibit 8 is my signature. PW 13, Bhanumati Tusad stated before me that on 17 to 18 at night, the deceased Shankar Tik came to my house. Before coming of the deceased Shankar Tik, my husband, along with line Chokidar Rajiv Bhakti, was sitting in my house. During that time, it was around 7 p.m. After elapsing of 10 minutes of coming of deceased Shankar Tik, accused Kamruj Bhumij and one Srila came to my house. During the time of the deceased, Shankar Tik asked the accused Kamruj Bhumij his muffler, and Kamruj Bhumij refused to give his muffler to Shankar Tik, and an argument and altercation had occurred. After half an hour of occurrence and altercation, accused Kamruj Bhumij, deceased Shankar Tik and Srila went away from house. And in the morning on 18 to 18 at about 6 p.m., deceased Shankar Tik was seen lying dead near Kali Mandir of my house. I saw injury marks on the face, forehead, and the head of the dead body of the deceased Shankar Tik. Later, I came to know that Kamruj Bhumij of our same line had murdered Shankar Tik. Exhibit 9 is a statement of Bhanumati deceased stated before me under section 161 CRPC. Cross-examination. I have not mentioned the time when I drew the sketch map and which is submitted in the case because as Exhibit 6. I have not kept any extract copy of the sketch map in my case diary. I have not taken any information regarding the distance between place of occurrence and the places of residence of the witnesses mentioned in the sketch map as Exhibit 6. The witnesses did not see the occurrences, though I have mentioned in my CD that I have not submitted the exact copy of the inquest report of the case records. I have collected the muffler from the place of occurrence, which is Exhibit M1. I have not collected any other materials such as blood stain, mud stain, fluid of the deceased from the place of occurrence. I have not seen any blood near the dead body. I have not found any weapons of offense near the dead body. I have not sent the seized materials muffler to FSL for examination. I have not seen any blood stain, mud stain on the muffler which I have seized. It is not a fact that I have falsely submitted charge sheet against the accused without properly investigating the case. May I please the the postmortem report response for one thing? Postmortem report, Miller.
Yes.
Page, Miller, it is at page.
Just give us 5 minutes.
Fine.
Sirlo and Shilu is the same person, probably.
Probably the same person. Right? Only the difference of pronunciation perhaps by this comes Sheila.
At any point, Bhanumati has said something about Bablu's presence.
No.
No reference to.
No
Babu.
reference to
So you referred to Rajiv
Bhakti.
11, P11.
Yes, who is not an again witness here, my lord. In the proceeding, he is not in trial, he is not a witness.
No, he's a trial, he's a witness, PW11.
Oh, sorry, 11, my lord, sorry,
11.
11. But he did not say anything, my lord.
The IO does not say on which date the present appellant was taken into custody.
No, my lord, present. Perhaps on 22, because the sentence in the paragraph, the second page,
Yes.
on 22 to 18, the statements of so-and-so Filumura was
Yes.
recorded. Later was followed, then my lord, it was accused was apprehended at his own home. No other separate statement is there, so it appears on 22 to 18 he was apprehended.
Okay. Accused was arrested, apprehended. Okay.
May I please the postmortem report?
Yes, please.
page 64, my lord.
64.
4, my lord. Injuries already I have read, my lord. That is multiple injuries are there, my lord. That is there. But my lord, lordship will see, my lord, page 64, examination time 1:45 PM.
Just a minute. Yes.
Then my lordship may come straight away to page 68, my lord.
Dispatch.
Approximate time since death.
What is this dispatch? 2:15 PM?
My lord, perhaps it should be 1:15 again, I don't know.
Cannot be
Dispatch,
2:15.
maybe the body was dispatched, my lord, and it was.
Cannot be. It cannot be done within half an hour.
My lord.
If you examine it 1:45.
Or it
cannot-
or it was 12:15, my lord, maybe.
It should be, it have been 12:15.
12:15, man. Now, my lord, page 68, my lord. It says within 12 hours.
Just a minute, please.
Approximate time since death.
Just a minute. Okay.
So, my lord, so it would be around, my lord, then if it is, my lord, as per this report, the death was around, my lord, maybe 2 PM in the night.
From where do you get?
12 hours within, my lord, 12 hours, approximate time since death.
Page?
Page 68, my lord.
Yes.
Examination was done at 1:45. So around 2 PM, my lord, the death occurred. 1:32 PM. my lord.
Within.
Within, my lord, within. So it's, let us will around 2 PM. my lord.
What are you trying to infer from this?
My lord, the quarrel which they saw, it was around 8 p.m. my lord. So there was almost 4 hours gap at least. Not 4 hours, there was 6 hours gap. 8 or 12 and then my lord, 4, it's almost 6 hours gap between my lord, the incident, my lord, the quarrel that people saw.
Date. No, the incident was of 17 to, isn't it?
Yes,
In the evening.
evening.
And in the evening, if it was in the evening, then at 18 to 1:45, the PM was done.
8 to 9 hours the fighting was there. Lordship. Then they have pulled out both the accused, both the deceased and the accused. As
8 and 9
Pilu Mura could not separate them.
Mm,
yes.
Bablu Orang came and he separated them both. Then 8 to 9 time only.
of
We
17.
cannot say exactly that it is an 8. Maybe not. Maybe it's a
No,
third.
that point of time.
8 to 9 8 to 9 is there. Then
This Mr. Rotta may not be a very, because he
Hmm.
gives the expected time of death within 12 hours.
Yes. So my lord, what I'm trying to say is, my lord, is
not
that what I'm trying to point out, my lord, is that there was a considerable time gap between, my lord, the quarrel, which that quarrel was not very, my lord, nothing fatal, my lord, because it was a scuffle which was separated, my lord. There was no use of any weapon, etc. They saw this people quarrel. That's the only thing they have seen, but nothing beyond that. What happened, my lord, between 8 and 9 and, my lord, 2 p.m. when the 2 a.m. in the morning when the death took place, or around at that time, no one knows what happened.
Why are you saying 2 p.m.?
Because we were within 12 hours of 18, my lord, 18th, my lord, afternoon, it was done at 2 p.m. my lord. So 12 hours, my lord, will be night of 17th, rather 18th morning, 2 a.m. in the 18th morning. And the examination was done on 2 p.m. on 18th evening.
1:45.
So 12 hours gap. Therefore, the death might have occurred around 1 p.m. or 2 p.m. So about 5-6 hours gap.
Within 12 hours. It might be within 6 hours also.
There was even if it's 6 hours, then the gap is even larger. So at least there is a gap of 6 hours. That is what I'm trying to say. Between 8 and 12.
No, we are not going too much because these are assumptions. This cannot be a conclusion, a definite conclusion. He said within 12 hours.
Yeah.
12 may extend to 16 or this side, that side.
Yes, but but then there are other evidences Lordship sees, my lord. Now PW8 is, my lord.
And here you are inferring that the last seen together, even if it's applied,
Yes.
they were last seen together at what time?
8 around
8 to
9,
9.
my lord.
8 to 9.
8 to 9. And there nothing happened really, so to speak, in terms of person dying.
Before that also at 7 p.m. there was a scuffle between them, Lord, in the house of
Yes, quite true. Quite true. That I'm not that is there on record that they were
then again there people saw fighting, Lord.
No, we'll come to you, madam, but at least one of the person, not Bablu, the other one,
Pilu.
Pilu or Chilu or something,
Yeah, Lord.
who saw them fighting and who was the first to separate them,
Them.
he has not said anything about the house
Yes.
of the lady,
Lady.
that he was present. He does not utter a single word about
That is-
Bhakti.
Bablu, Bhakti or
No,
Bablu?
no, not Bablu.
Ba-
Bablu, he says. Bhakti.
No, Bablu also doesn't say, my lord.
Bablu, he says that Bablu, he called Bablu.
PW10, my lord.
Yes.
Pilu Murra, I intervene. No, my lord, he doesn't say. He says that I stopped the fighting. He doesn't say anything about Bablu, my lord.
Bablu says that I asked.
Bablu said that I asked, Pilu asked me to intervene, but Pilu doesn't say so. Page 19, my lord.
Okay, okay. Stop the fight.
Thereafter, I went to my house. Thereafter, the accused told me at my house that he had killed Shankar.
So when did Shankar come to his house in midnight?
Pilu also does not say anything about Bablu.
Bablu. He doesn't say.
The defense have also not taken any view regarding this, Lordship.
No, why should they take a plea? Why should they ask them? You did not say anything about Bablu. Did you see him? Yes, yes, yes. I forgot. Yes, I saw him.
It is the accused did not tell me. That
No
it is-
Bablu, no Bhanumati,
No one.
residence.
Nothing, my lord, nothing. And what time Pilu confessed? Lord, Bhumi's concept, Kurmu confessed. He said he came to my house.
My house.
Nothing, my lord. At midnight, or when, my lord? And he also says that they went away to, my lord, they went away from their house. So they went, and Bablu says they went in different directions.
That the muffler was recovered.
Bablu, PW says, my lord, accused and
আপনি মোবাইলত ডেট চাব জানেনে? ডেট মোবাইলত ডেট just you have the mobile phone,
my lord.
just check up whether 16th of August 2018 was a not 16th of August, the date
18th August, 17th.
17th of August, 17th of February 2018 was a Saturday. না লাগে না, দেখা না লাগে 17 to 2018. But that will not make much of a difference whether it's a Saturday or not. Witness might forget a particular date, but
Yeah.
I'm just trying to ascertain. He said Saturday.
Saturday.
It was a Saturday.
Yeah.
It was-
I'm just.
Mr. Islam is also very interested in this case. Or maybe he's seeing something else. Cannot find out. 2018 calendar you'll have,
No, my lord, not the.
it's not there. Okay,
It's
doesn't
not
matter.
coming up, my lord. It's not out of the.
In the Google you'll have,
No, my lord, the maybe with the network issue, my lord.
okay, okay, doesn't matter.
Network issue.
Doesn't matter.
Ah, my lord, this come.
Friday, Lord. No, not Friday.
No, it's 17
No,
to 17 to
17th August.
17, not
Sorry,
August,
sorry,
17
sorry.
February
17th February.
2018.
Lordship, Saturday, Lordship. 2000.
Huh?
No,
18.
18.
18.
It's a
2018,
Saturday.
17th of February,
Saturday.
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 That much he'll come prepared. One witness.
Then, my lord, he says that he intervened and stopped the fight. Where Bablu says, my lord, that he could not stop the fight. That PW10,
And he called him.
he called him, and he was coming from somewhere else. While I was returning from work at around 9 p.m., I saw deceased Shankar and Kamuz were fighting near the people tree. Then one person named Chilu, who was residing in so-and-so, called me and asked me to stop the fight. Then I pulled out Kamuz
Let us assume this Chilu to be PW10.
10.
PW10 does not say anything.
He
about
doesn't say anything.
Pablo.
Then he says both of them went with the accused and the
Different
deceased,
direction.
different directions. Then I and PW10 went home. I do not know what happened.
And
And-
he goes to home along with PW10. Even then, PW10 does not say anything about
Doesn't.
PW8.
8.
Rajiv Bhakti does not say anything about going to the residence of Bhanumati.
Yes.
He saw the fight. Fight started there, according to Bhanumati.
According to Bhanumati, it
It
started.
started with a muffler
Yes.
at her house.
Yes.
Then they came out.
Yes.
Let us assume that it came out, the fight continued.
Fight continued.
Rajiv does
And
not say anything.
If her statement is believed, then Chilu also came out with PW10 also came out along with them.
Yes. Shilu does not say anything about Bhanumati.
Doesn't say anything about that.
He said under the people tree.
Yes.
First, he said that the accused were at Kherpatti, near People Tree. Where is Bhanumati's house? PW 13?
Bhanumati's house, PW 13 is at station, line number 10. It is line number 10. They call it wrong T, line number 10.
Nothing is discernible.
And Kherpatti,
Nothing is discernible.
PW 8, PW 8. PW 10 again says, my lord, that fighting at the people tree at Digaliturong, line number 10. He doesn't specifically name Kherpatti.
No, he says one thing. He says Kherpatti. PW 10 says.
No, PW 8, my lord. I'm talking about PW 8.
8.
PW 8 doesn't name Kherpatti. PW 8 only mentions People Tree, line number 10, Digaliturong Tea Estate. Now, Bhanumati's resident is at Digaliturong Tea Estate, line number 10. To that extent, the place of incident appears to be near. But whether Kherpatti is the same place, of course,
Okay, doesn't matter. Yes, please.
doesn't matter.
Yes, please go ahead.
Now, my lord, on the basis of my lord, PW 10, my lord, the entire conviction has been held, my lord. This is an extrajudicial confession, my lord. There is a huge gap, my lord, there's a considerable gap, my lord, in the occurrence, death and the, my lord, alleged fight, my lord, which they saw. And my lord, there are lots of seen, there are contradictions in the evidence of PW 8 and 10. And PW, it's basically with the PW 10 who says that the confession was made before him. And neither of them, none of the witnesses saw anything which could have led to the death. A fight regarding a muffler.
What is the law regarding extrajudicial confession?
Well, it's a very weak piece of evidence, and it has to be, my lord, of a Starling kind of witness, with a witness with a Starling quality, my lord.
Yes, I mean.
My lord, I'm relying upon one judgment, my lord, and that, my lord, both these aspects have been taken care of.
PW 13 now enters statement said at the time of examination of PW 14. Whatever she stated before him. He required a judgment at all cross-examination. And if PW 39 police or key person enters statement and said, but this statement was followed, though she declared as a hostile, his statement would quote chapel, but his statement on his from that regard is what at all with him. Also
Quotation is 160, not direct quotation of 164.
Direct section
164.
This
Seems to be written
you don't get a time about equal local across a person in life on people. Money here regarded to cost of
Yes.
My lord, this is judgment, my lord, 2012, my lord. Paragraph 21, my lord, with regard to my lord, extrajudicial, my lord, confession. My lord. The principles.
Yes.
For paragraph 22, my lord. The principles, the extrajudicial confession is a weak piece.
What is the name?
My lord, name is, my lord, my lord, Sahadevan. Sahadevan versus State of Tamil Nadu, my lord. It is 2008, 2012.
That we have found name gets slightly. Sahadevan.
Sahadevan.
Spelling?
Para 22, my lord.
Spelling.
SAHADEVAN.
DEVAN. VAN.
Man.
And another.
Versus State of Tamil Nadu.
Versus State of Tamil Nadu. Okay.
2012 Supreme 2012 Supreme Court 2435.
Paragraph?
Para 22.
22. Yes, please read.
Upon proper analysis of the above judgments of this court, it will be appropriate to state the principle which should make an extrajudicial confession an admissible piece of evidence capable of forming the basis of conviction of an accused. The percepts could guide the judicial and mind while dealing with the veracity of cases where the prosecution heavily relies upon extrajudicial confession alleged to have been made by the accused. The principles The extrajudicial confession is a weak piece of evidence by itself. It has to be examined by the court with great care and caution. It has to be made voluntarily and should be truthful. It should inspire confidence. An extrajudicial confidence attains greater credibility and evidentiary value if it is supported by the chain of cogent circumstances and is further corroborated by other prosecution evidences. For extrajudicial confession to be the basis of conviction, it should not suffer from material discrepancies and inherent improbabilities. Such statements essentially has to be proved by other fact and in accordance with law. So here, my lord, this appears there are a number of contradictions are there, my lord. Then the chain is also not complete, my lord. The other chain doesn't support, my lord. Then, my lord, in the same judgment, my lord, para 31, my lord, the last sin theory.
Yes.
31. With the development of law, the last theory of last sin has become a definite tool in the hands of prosecution to establish guilt of the accused. The concept is also accepted in various judgments of this court. The court has taken a consistent view that where the only circumstantial evidence they can resort to at the prosecution is that the accused and the deceased were last seen, it may raise suspicion, but it is not independently sufficient to leading a finding of the guilt. Now here, my lord, they were seen quarreling. That may not be sufficient. That is not sufficient, my lord, to hold them guilty of the guilt, my lord, offense. They in so-and-so versus so-and-so, the court took a view that the appellant were alleged to have gone to the house of one Sitaram in the evening of 19 July 1985 and stayed in the night at the house of the deceased. The evidence was shaky and inconclusive. Even if it was accepted that there it would be at best amount an evidence of the appellants having been last together, seen together with the deceased. The court further observed that it is settled law that the only circumstance of last theory will not complete the chain of circumstances record a finding that it is consistent only with the hypothesis of guilt of the accused, and therefore no conviction on that basis alone can be founded. So here, my lord, it cannot be said, my lord, that it is the only hypothesis possible just because they were seen quarreling at some point of time in the evening. Considering, my lord, the time gap around which the death occurred, and my lord, the circumstances under which that, my lord, and the statement of my lord P.W. Ken, my lord, being the only, my lord, the extrajudicial confession purportedly made before him, being the only basis of my lord.
That's all?
Well,
Yes. Madam?
As the conviction is on PW 10, Lord. Then Lordship is a settled position of law, Lord. Why should we disbelieve him? Because we have no enmity, Lord, with the deceased.
The question is not of
And-
disbelieving. We believe him. There's no question. We believe whatever he said, we believe, but will it be sufficient to uphold the conviction?
But there was fighting. It is also, it is not Lordship denied by that there is no fighting. Two witnesses have already said that there was a fighting in the period between 8 to 9, Lord.
Okay.
And the PM report, Lord, that is also telling, Lord.
No, PM
That-
report says
that
use
12
of
hours.
heavy, blunt and sharp weapons.
That nobody has seen that.
Nobody has even
Nobody.
uttered that there was some sword or anything of that
Nobody.
kind. Fighting was seen.
Fighting was seen and they have departed them from the fighting, but nobody knows that what had happened.
Yes. Under
I-
that
I-
context, last seen theory would be
Lordship,
may be applicable if you make out a case.
Lordship, that is I'm saying, Lordship, that because nobody have seen after that. Then the PM report is also
See, how do
telling-
you connect a last seen theory and how do you apply it?
Because-
They are last seen together, thereafter, one person is found dead. Then
Found.
what do you get in the, on the body of the person who has been accused of the murder?
Lord.
There is no examination done, no blood stains even collected. The muffler was seen to be without any blood stains.
Here,
He was arrested from his own house. He
So
was
there-
not found absconding. These are certain aspects which will come into consideration.
but as it is,
What has actually happened, nobody knows.
Nobody
But
knows.
what we are concerned is
we have
whether
voluntarily
his
confessed that-
implication, his complicity has been proved beyond all reasonable doubt. That is what we are concerned with.
But his extrajudicial confession, he has done voluntarily. There is no such that he was put on pressure, under pressure, he have confessed or somebody have asked him to confess. That's
See, what is the extrajudicial confession? Let us again come to PW 10. He,
PW,
accused told that he had killed the deceased. That is the only statement. Is there any description? Where was he killed? How was he killed? Was his in a shock of state? This person, he comes to his house. Why should he come to his house and say that, yes, I am?
without any reason, why one will take the burden of murdering one and saying that I
And
have killed.
come to his house.
Sir,
If he was caught somewhere, what were you going? Then maybe he told, he comes to his house, he confesses, then goes back. What time did he come?
But-
Where is Rajiv Bhakti? Where is Bhanumati?
There was a already altercation regarding a master. In the village area lordship, their altercation are always within a small.
No,
thing, like-
altercation is one of the factors we are definitely
That is their
taking into
lordship
account,
for
but will
the-
that be sufficient?
That is in 7 o'clock, Lord. Then again they started fighting, Lord. The time gap, Lord. And at the 7 o'clock, there was altercation again. And
7 o'clock, from where do you say 7
That
o'clock?
is from PW 13 lordship,
Bhanumati,
lordship,
is 23.
lordship. A person at about at around 8 a.m. I was cooking.
Where?
Lord.
I was cooking on the next moment. No, that is not that. I know that is
It is
alone.
not the fact that I told on the 17th that this is Shankar, Sikh, my husband, along with the line Chokidar. Rajiv Bhakti was sitting in my house. During that time, it was around 7 p.m. After elapsing of 10
No,
minutes.
this is the suggestion which she has denied. This is not her statement. How does it start? It is not a fact. These are statements which the police alleged that she had made before the police. See her chief, why she was declared hostile. In chief says something else. 1 year before
1 year
ago, she was at 8 p.m. She was cooking meal in her house alone.
alone.
And after taking my dinner, she went to sleep. She says nothing. Though she was produced as a PW. On that, she was declared hostile. Then he said, and you have said before the police this. He says, no, I have not said. This is one of the foundation. My illiterate, I do not know how to read and write. See, interestingly, in PW 13, after declaring her hostile, this statement was put to her that she stated before the police. Nothing was put to her on the 164. 164 same statement is made. And if we cannot discard a 164 statement.
That we cannot.
If you come to 164, even if you discard this cross-examination, 164, she says that quarrel was at her house. Shankar, Kumru, and Sirlo went out together from her house.
Good.
At page 88.
Then the time was 7 p.m.
Page 88.
88.
Though that is not an evidence in the doc,
Mm.
but that
But
can
164
corroborate.
From the 164, it seems that 7 p.m. there was a altercation.
17th he came.
They আহিছে তাৰপিছত ওলাই
They
গ'ল।
came.
They came.
It
After
doesn't say
10
the
minutes of
17th that
the-
he was-
this is
They
after
came.
10 minutes. This is Shankar Sikh arrived in my house, resident in the same line. The Kumru Bhumit accompanied by came to my house. After তাতে কাজিয়া বিলাক
After half an hour of the quarrel.
and after half an hour of the
And she
quarrel,
did not say about any fight. She said quarrel.
quarrel was quarrel was there. Then Lord, after half an hour of the 7:10 they have received reached there. And after half an hour
Of the quarrel.
the disease, Shankar Sikh, Sri Kumru, Bhumit, and Serlo together went away out of my
Hmm.
after half an hour. Then PW 8. Again he told it was the time was 8 and 9. There was a fighting. First there was a quarrel, then there was a fight.
No, Sirlo, at least he should have said, yes, we are at Bhanumati's place.
That
We
they
came out, there was a quarrel, then again they started fighting at People Tree. I tried to separate them, I
Separate
could
them.
not. I called,
Kumru Bhumit.
no, not
Bablu.
Bablu, he doesn't say anything. It needs to be consistent.
There is at the time also is there like that postmortem PM report. Though there are weapons are
Kindly formulate which, what you want to say.
not prosecutor succeeded in proving the case lordship beyond reasonable doubt in because by adducing 8 and 10 lordship. Because the PM report also says that about the time. And there is extrajudicial confession which is not, it is done voluntarily, lordship, and no enmity is there between them, lordship. That earlier there was no such, nobody have mentioned that there is some enmity between this person. To give such a pause. Which
See, let us, PW 13 has been declared hostile. Ultimately, we cannot be too much of a reliance. 8 and 10 are the only witness.
only with
Let us again read 8 and 10, compare them and say whether those are consistent.
Right.
Some things
Right.
may be omitted, but there has to be consistency.
Right.
One witness may not say everything,
lordship.
but he cannot say something which is not, which is something which is contrary to what the other one has said.
If he could remember Saturday, my lord, he could have also remembered that Bablu was also there. He wouldn't have just forgotten about Bablu that day.
But it is not mentioned about. Question.
Let us read 8 and 10 again.
Lord, the-
8 is at page 17,
lordship,
16. Page 16.
Page 16.
Yes.
I know the informant and the accused. Both around 3-4 months ago, the incident took place while I was returning from work around 8-9 p.m. I saw disease, Shankar and accused Kamroj were fighting near the People Tree, which he also says first, of line number 10 of Tigholtarang Tea State. Then one person named Chillu who was reciting line number 10 of Dighal Tarang TE called upon me and asked me to stop the fight, as he could not alone stop the fight. Then I pull out Kumruj and Tillu pull out the deceased Shankar. Then both of them went away in different directions. Then I and Tillu went home. Do not know what had happened. Next morning, I saw people were gathered near the people tree of line number 10 of Dighaltaram CE. Then I went there and saw Shankar was lying dead on the ground. Police came to the place of occurrence and recorded my statement and took me to the court and recorded my statement. Exhibit 4 is the statement. Exhibit 4.1 is my signature. Cross. It is not the fact that I do not state before police and court that I saw deceased Shankar and accused Kamruj were fighting near the people tree of line number 10 of Dighaltarang T. Near the place of occurrence, there were residing of many people.
There were residents.
Sorry. There were residents of many people. It is not a fact that I
So
deport-
this suggestion is important
important.
because if it is a place where it's
People are residing.
it's habitated, then nobody is there. Why?
Nobody.
Then come to 10. At page
Page number 19.
19.
I know both the informant and the accused of this case. The incident took place around 3-4 months back. The day was Saturday. The incident took place at night. Prior to the day of incident, myself and the accused were at Khairpatty near People Tree. I saw the deceased and the accused were fighting. I intervened their fight and stopped the fight. Thereafter, I went away to my house. Thereafter, the accused told me at my house that he had killed Shankar. Then I told him to go to his house. Police recorded my statement. I was also brought to the court and my statement was recorded in the court. Cross. It is not a fact that the incident did not take place around 3-4 months back. It is not a fact that the deceased and the accused were not fighting. I do not know the contents of the Azahar so and so has been given before the court. I do not know as such. But if that is, there was a relation between before the incident took place prior to the day of the incident, myself and the accused. He was there, Lord. The Pillu, myself, Pillu and the accused were at Khairpatty near. One, we have not mentioned this PW8 name, but the place is Lordship near People Tree. So it's Khairpatty.
Come to page 86. Page 86. This is 164 of this people.
Pillu. On the Saturday,
On last Saturday, it's a very recent, immediately after the incident.
Right.
It is recorded when? This is recorded on 23rd of February.
on
23rd of February. Just after 5 days of the incident.
5 days.
Okay. Please read on last Saturday.
Last Saturday, a quarrel took place between Sri Shankar Sikh and Sri Kumru Bhumi, some other person.
Are some other persons. And I.
Together stopped their quarrel and thereafter I went home. Later, Sri Kumru Bhumi came to my house and told me that he had killed Mr. Shankar. I do not have anything more. In 164 also, he have stated about the extrajudicial. Some other,
Here he says some other
Some other
persons and I stop in his, as a
Quarrel.
witness before the court.
Court.
As PW 10, he did not say anything. He doesn't say anything.
he did not, some people.
No,
other
not some people, not even Bablu. No, he doesn't say anything. PW 10.
About the quarrel, he said. Lord
Quarrel
Chief.
he said.
The-
I intervened their fight and stopped the fight.
Whereas,
No,
Madam,
no.
Bablu in his 164 statement also mentioned Pilu. His statement is consistent, but Pilu's is not.
And Pilu will be more important because it is Pilu who claims that the appellant had come to his house and said that he had killed.
He had killed.
Let us see how has this been taken care of? The conviction? Mr. Datta?
Page number
40, paragraph 42 onwards, page 53 onwards, question in there.
Page,
underline
Page 53 onwards,
53, paragraph 42
paragraph 42.
has pointed out that the PW 8 and PW 10 have deposed that before the death of the deceased, an altercation had occurred between the accused and the deceased. It is also pointed out that PW 10 has deposed that after going home, the accused came and told him that he had killed Shankar deceased. Thus, the prosecution has succeeded to prove the case against the accused person beyond all reasonable doubt.
Paragraph 48, it says, page 57. From the facts and circumstances, it is proved that the accused himself went to the home of PW 10 and confessed the guilt voluntarily. The defense side could not create any doubt that the confession made by the accused PW 10 is a result of inducement that was promised as envisaged under section 20 of the Evidence Act. From the facts and circumstances, it is proved that the extrajudicial confession by the accused is voluntarily. Defense side could not create any doubt as to why the PW 10 shall give false evidence against the accused person. Hence, PW 10 statement so far as the extrajudicial confession of the accused is concerned becomes reliable and trustworthy. The defense side could prove the animosity between PW 10 and the accused, PW 8, 10 and the accused. The defense side could not prove why the PW 8 and 10 would give false evidence against the accused person.
I think this should be could not. First 49, first line.
Yes, ma'am.
Could not prove.
Could not prove. The prosecution could not create any contradiction in the statements of PW 8 and 10, and hence
Why? PW 8 and 10, why there is no
why there is no contradiction. Therefore, it has become reliable and trustworthy.
No, extrajudicial confession may be a relevant piece of evidence, but it is necessarily required to be corroborated with other evidence.
Correct.
That alone cannot. It's a very weak piece of evidence. And why is the requirement of having a dying declaration before magistrate or anybody? And this is not even a dying declaration.
No.
This is
No.
by a confession rather.
Confession.
Even a confession made before the magistrate, if it is not done by following the procedure, it is not been to be
Not
not to be regarded.
Yes.
And if you see the form, the safeguards which are to be or the regards which are to be maintained before recording a confession, it is filled up with so much of details.
Yeah.
Every minor details is taken care of. Whether it has been done with a free mind, without even thinking about, even knowing fully well the consequence of such confession.
Yes.
Here, he just makes a statement, he comes to my house, says this. What time? What was his state of mind? Nothing. See, we are repeating, it may be a matter of fact, but to accept that to be a evidence beyond all reasonable doubt, that is not permissible.
Even PW 10, my lord, though not imputing anything, to keep himself out of any harassment, he might simply say that since they all things together, last my lord, he might simply say that to keep himself out of the thing, my lord, that he had killed him, therefore no harassment for me, at least. It's also possible. my lord.
PW 10.
10, my lord, because they were seen last together, my lord, three of them. So to keep himself out of this, my lord, entangle, my lord, he might just simply say,
There is
my lord,
nobody other. Else.
Bhanumati said that who went out together?
two of them. The
Three.
accused, Disease and Chilu.
And what about Rajiv Bhakti?
Rajiv Bhakti Miller doesn't say anything.
No. What does Bhanumati says about Rajiv Bhakti?
Rajiv Bhakti was in the house.
Only. he was
They
in the
didn't, he
house.
did not go out with them. The three went out.
23, page 23.
My husband, along with the line Chokidar Rajiv Bhakti, was sitting in my house.
They were there from prior to the arrival of the accused in the dispute.
No, that was the denial actually.
That is denial. No, in
That
fact,
is the denial.
denial.
Because that after declaring her hostile,
Yes.
to the question, she
Yes.
says it's not a fact.
Yes.
Maybe this was the statement before the police.
Well, Bhanumati in 164 statement states that Shankar Sheikh, deceased, Kamru Humiz and Shirlo went out of my house.
88.
88.
That we have noticed. That was made on 23/2/2018.
Yes.
Anything else, madam? Any case? Case law?
Lordship. I have got one extrajudicial confession, but I thought the first half, Mr. Bora's case goes to second half, I'll have.
You give it to our court master.
Sure.
We'll consider. And give the correct citation. Yesterday you had placed us in difficulty.
Lordship, I have then over, I have.
That
This
case of
said-
Balveer,
No.
we were seeking and we did not. Only after contacting her,
Actually, I was not.
give correct citations.
Today I'll give.
Don't put us in difficulty.
No.
We had to
Sorry
search
for
and
that.
search, we did not find
Sorry.
Balveer. Okay. I'm Dr. M. I. Kasan and A. Begum. Hearing conclude, judgment is reserved. We are reserving it. Give the judgment tomorrow.
I'll.
Deputy Lordship.
After.